Hello, and welcome to the Ask an Author webinar series. Today's topic is evidence in real time. Before we begin, I have a few housekeeping items to review. The audio for this webcast is through your internet only, so please use a headset or earbuds, or view this presentation through your laptop or mobile speakers. Secondly, this is a one-way communication channel. You can hear us, but we can't hear you. So if you have any questions or comments, please use the chat feature to your right. And now I will hand it over to Anton to introduce today's presenters.
Hello. Thank you so much for joining us for this presentation of evidence in real time from Professor Laurie Levinson and Justice Brian Hofstad. I'm going to introduce our presenters. Laurie Levinson is the Professor of Law and David W. Broacham Chair in Ethical Advocacy at Loyola Law School, where she teaches criminal law, criminal procedure, white-collar crime, ethical lawyering, evidence, and advanced trial advocacy. Levinson joined Loyola faculty in 1989 and served as Loyola's Associate Dean for Academic Affairs from 1996 to 1999. She's been a visiting professor at UCLA and USC, and D.N.L. Strauss Distinguished Visiting Professor at Pepperdine School of Law. Laurie Levinson has co-authored with Justice Brian M. Hofstad the new casebook, Evidence Law, Practice, Problems, and Policy, which just came out from Aspen Publishing this September. It's a straightforward and accessible casebook that provides a foundation for students to learn and apply, both in litigation and transactional practices, federal and state evidence laws. Laurie Levinson is also a co-author of Criminal Procedure with Erwin Chemerinsky, which is currently out in the 4th edition, also from Aspen Publishing. She is the author of 14 books, including Levinson and California, A Criminal Procedure from Thomson Reuters, and Complex Criminal Litigation, Prosecuting Drug Enterprises and Organized Crime with Jimmy Gurley and Mark Bonner, as well as many law review articles and other publications. Professor Levinson is the founding director of the Loyola Project for the Innocent, the Loyola Center for Ethical Advocacy, and the Fiedler Institute on Criminal Justice, and senior faculty for Loyola's Journalist Law School. The Honorable Brian M. Hofstad has served as an Associate Justice on the California Second District Court of Appeal since 2014. Prior to that time, he spent 4 years as a Los Angeles Superior Court judge, 3.5 years earlier as a partner in Jones Day's Issues and Appeals Practice Group, and more than 6 years as Assistant United States Attorney prosecuting criminal cases, and 3 years doing legal policy work in Washington, D.C. Right out of law school, he clerked for Ninth Circuit Judge Cynthia Holcomb Hall and Associate Justice Sandra Day O'Connor. Hofstad has for many years been a teacher to judges, lawyers, and law students. In addition to co-authoring with Laurie Levinson the new book, Evidence Law, Practice, Problems, and Policy, which I just mentioned, he is the author of California Criminal Discovery, on its 6th edition, and is a regular contributor to the Daily Journal. He's published articles in UCLA Law Review, Duke Law Journal, Texas Law Review, Northwestern Law Review, and Southern California Law Review. And he is a lecturer in law at USC Gould School of Law. So with this, I'm going to pass it on to Laurie Levinson.
Thank you so much, Anton. And I'm so happy to be here. Now, I realize we're competing a little bit today with the January 6 hearings, and I promised that I would give you an update. You know, these hearings today are much more like a closing argument. And so you might pull up snippets of those to use with your students. But what we're here to do is sort of give you an overview of some of the ideas we have in teaching evidence. And that's what we kept in mind. So last time, I'm going to shamelessly show you this book. When we wrote this book, I really looked forward to writing this book with my co-author, Justice Hofstad, Brian, because I knew that if we got together, somebody in his position who practiced and regularly makes decisions And someone in my position who worked as a federal prosecutor but has been teaching for 34 years, we would come up with some ideas that would refresh, excite people. Now, the update I promised you on the January 6th hearing is basically this. The theme for today's hearing is it was Trump. It's all about Trump. It was all about Trump holding the election, and then a series of hearsay, as we would say in an evidence class. But we're going to do things a little differently. What we wanted to do is give you an idea of a scenario and how you can use that scenario if you are teaching evidence, whether it be in a classroom or we often teach with judges or with bar groups, just to really enthusiastically convey not just the rules, but how they apply. And in our book itself, we have a bare bones book. It has what you need. It has the rules, it has advisory comments when you need it, it has the basic cases, but it also has a package. And the package will be the supplement that have tons, hypomania, tons and tons of problems. And we have a chapter that deals with a real life scenario, a case called United States versus Webster, which is one of the January 6 cases. And from that, building hypos you can use in the class. Today's scenario is not a real case. It is a fictional case. But nonetheless, our goal here is to try to address some of the more interesting and challenging issues that come up in evidence law. And we'll be happy to answer questions from you as well. Because even though I've been teaching evidence law, well, my students say since the earth cooled, I've always learned new things. And we're always sort of readjusting to how the courtrooms are actually working. So with that said, I'm going to turn to Justice Hofstad, Brian, to present an overview of what we're talking about today, and then we'll get into the actual evidence issues. One of the things I want to mention is you'll see slides that we're using today. We provide with the book, as I said, a full package that not only has problems, but will have PowerPoint decks for each chapter, and it'll have sample pleadings, that might apply, and transcripts, and as well as references to videos, if you're the type of person who likes to show a clip to illustrate what you're teaching. Brian.
Thank you, Lori. And it's wonderful to be here and be able to talk to everybody. As Lori mentioned, the theme of this presentation is evidence in real time, because what we're trying to convey is that the book that we put together is nimble enough so that you can apply it to situations as they unfold and to keep things live, and to sort of show the students in a real world way how the evidence code really applies from day to day. As she mentioned, our hypothetical that we're going to pose today is not based on a real case, but it is based on a January 6th prosecution, a fictitious one. The prosecution that we have here involves the United States Attorney's Office charging a fictitious person named Charles Patrick, who goes by the moniker The Patriot, with two different crimes. The first is an assault on a Capitol Peace officer. The officer's name is Aaron Marcus, as well as conspiracy to engage in sedition. I wanted to just follow up on a few points that Lori raised about what you're going to see. What we've done is broken this up into 8 different sub-questions or hypos that present different evidentiary questions that come up in this hypothetical trial. And then what we've done from there is to sort of walk you through how we would approach using the book and the materials in the book to lead the students through these questions. Lori mentioned that we put together a PowerPoint deck that goes along with the case book. The deck has, I think, close to 1,400 slides. You'll be able to see which slides we're lifting right from the deck because they're in the sort of teal, light teal, dark teal color scheme. You'll see a lot of other graphics and charts and diagrams that we put up that are in more of a red, black, and white color scheme. Those are graphics that are put in the book, or that come from the book itself. Many of them are replicated in the PowerPoint slides, in the PowerPoint deck as well. But the point there is to show that the book, not only we try to take a very easy to understand approach in explaining it, but for those students who sort of learn more spatially and graphically, there's a lot of graphs and charts and tables that lay out sort of the interrelationship between a lot of the different evidentiary concepts to make them easier to understand as a whole, even though we're learning them sort of one piece at a time. So with that setup, I will now hand the gavel back to Lori to do the first hypothetical.
I'd be happy to do so. I do want to mention, folks, that obviously we're focusing on a federal case here, and we have federal background, but of course, Justice Hofstad Bryan is a California State Court of Appeal justice, and we are all familiar with some of the major jurisdictions. So those are in the book as well. They refer where they're different, might things be handled in other states, and those might be states related to you. Today, we're going to be focusing on those federal rules of evidence. And the first question is, look, cases start with what does each side want to present to win their case. In this, the first issue is that the AUSA, the prosecutor, seeks to introduce evidence that the defendant belongs to the Confident Kiddos, a clique of the Proud Boys. And the defense says objects. Early in the book, we talk about how important it is to object, the standard types of objections, preserving the record, standard of the review. It's all on there. But today we're diving into a real case. And I love starting with the issue of relevance, because in my experience, it gets the students talking about, from a common sense perspective, what they're concerned in the case. For the prosecution, they have to start thinking about, what do we have to prove? And only if you think about that can you get to the point of, how am I going to prove it? And that raises the issue of relevance. Now, as we all know, and the defense on the other side is going to say either I don't think it's relevant, or they're going to go to 403 that we're all familiar with, it's relevant, but. So the first step, and we break it down as clearly as we can, because even though I found that this is instinct for all of us who've been in the real world, for students it's not. They haven't tried cases yet. Some of them, most of them haven't even watched cases except for the ones on TV, which may or may not follow any rules. So we're giving them the approach. And step one, as you know, is 401, which is, is the evidence relevant? Is there any logical relevance to the evidence? Can you use your common sense to put together how this piece of evidence will help to prove the case? And in the next slide, we'll talk about how much it has to help. But going back for 1 second, we then go to the pragmatic question. As we all talk about what 401 giveth, 403 can taketh away. Because in the situations where, even though the rules are in favor of allowing, frankly, as much evidence as possible in, that was a choice that was made by the drafters, to not screen too heavily, but give that discretion to the judge who's in the courtroom and can see and feel everything that's going on. There are going to be occasions where you worry, okay, it's relevant, but that relevance is substantially outweighed by other considerations. Going to the next slide. That's what's laid out here, right? Which is the idea of the logical relevance. And we can make the logical relevance, how is it relevant that this guy belongs to this group? Well, if you're proving a case, you have to prove perhaps identity. Is this really the person in the picture? And the more they belong to the group, the more likely that is. Motive, intent, all of those are issues that are relevant. The value, though, is making students articulate, why do you want to get that evidence in? How is it relevant? And in terms of how relevant it has to be, again, the drafter said it just to have any tendency. It doesn't have to prove the case more likely than not. That's what we mean by probative. But the other part, what we mean by material, is that it shows something that needs to be related to the case, that needs to be proved in the case. It might be an interesting story if you're reading it in a novel, but that's not what courtrooms are about. They're about deciding cases. So on the practical relevance, we then get to the question of, if we have probative evidence, and most everything is going to be probative unless it's out of far field, then the question is it probative enough given the concerns that we have about other things? Like, is it misleading? Is it prejudicial? Go to the next slide. And here again, I think it's really a useful step. to have the students articulate why they would be concerned about this evidence. Because even though it goes to identity, are you going to be punishing somebody for belonging to an organization? And they have an instinct that, in America, you got a First Amendment right. But what they might not realize that there have been cases, and we include at a point the Abel case in our case book, where you had somebody who in prison belonged to one of the prison gangs. Is it going to be something where the jurors, when they hear that, are going to be so inflamed, make a decision based upon bias or emotion or assumptions, that the probative value is substantially outweighed? And there are lots of aspects. In some cases, it may be because you're calling too many witnesses, you're wasting time, you're hitting on emotion, you're misleading the jury. But that's the practice. So let's go back to our case here. Next slide. We've got, I'm sorry, go back. I'm sorry, Brian. The argument would be that he belongs to this group, and this group is what? The confident kiddos. And if I were the defense lawyer, I would argue, Judge, they're just going to judge him for being in the wrong group, and therefore you should keep it out. Oftentimes the question comes up, our hypos are asking, how would you rule? You know what? I don't necessarily tell students how I would rule, because I think the goal here is having them learn how to make the arguments. But in my own experience, I wouldn't be surprised if the evidence were allowed, and then we get to this next important point: the judge tailors the evidence, because the judge has the broad permission to do that. All right. That's why we're concerned about propensity evidence. The idea that somebody might have committed a crime before or been involved in the wrong things before, it would then say they automatically did it before and they must have done it again. So that's something that I think students need to keep in mind when we get to the whole area of 404B. Let's go to 404B. 404B is another aspect of relevance, right? It's under character, but it's not admissible for character. It's only admissible for another purpose. So even though you have evidence that you might show, oh, he's that kind of person, we all know that the federal rules don't allow that. We don't judge people on the kind of person they are, except in a few exceptions, but on what they did. And that's why under 404B, students have to get used to identifying what is the 404B purpose of this prior act, right? Does it go to identity? Does it go to motive, opportunity, modus operandi? And when you do that, you're going back to that idea of, the purpose, how probative it is, the prejudice. Can we limit the prejudice, perhaps with some type of instruction, or how the evidence is presented, or how many witnesses address that, and get to the right balance? That, Brian, I think is sort of giving the overview of how we approach this. I like to layer onto it that in my own experience in criminal cases, courts are obviously much more concerned, but things like relevance and 403 and 404B absolutely apply in civil cases as well, even though many civil practitioners don't think about it.
And what I oftentimes do, it sounds like you may as well, Lori, is I will sometimes, especially for 403 type issues, ask the students where they come out with a polling software or whatever else, or by show of hands. And oftentimes it'll be close to half of the class votes for each. And I'll oftentimes point out, for a lot of the issues, both sides would be affirmed on appeal. Because 403 gives you a huge amount of discretion. And while we're trying to teach them the limits of that discretion, it's important in doing that to also emphasize there's a lot of discretion there that they have. And the courts can legitimately and reasonably decide the same 403 question in different ways and both be affirmed, given the breadth of discretion that they have there. The next question that we have, the next hypo within the hypo, is that the defendant claims that Officer Marcus had an excessive force claim that was filed against her, sort of an accusation that was made against her in 2017. And there's an objection on relevance grounds. And I think that this sort of raises both some relevance issues as well as a potentially subsidiary hearsay issue. And this follows on nicely to the relevance issue that comes up in the first typo. When we're dealing with 403, the way the book sort of deals with that is that's an item by item limitation on relevance, where you look at each item of evidence and engage in the balancing. And the book conceptualizes several other different limitations on relevance in sort of more a categorical fashion. These are rules where the drafters have done the balancing of probative value and danger of prejudice in advance and have sort of come up with these rules that are followed as to how to admit these different categories of evidence, in addition to, or at least in before you get to the 403 analysis, even with these. And these include everything from the 407 to 411 group with subsequent remedial measures and pleas and compromise negotiations. All of those have sort of categorical rules. And we also look at and conceptualize the character rules as being very similar, where they've set out these special rules of relevance that have to be applied. As we all know, and as Lori alluded to, the general rule is that propensity evidence is not allowed. You can't show that because someone did something in the past, they're this type of person, and therefore they did it again. One of the notable exceptions to that is in criminal cases, the defendant can introduce the victim's character, typically the victim's character for violence. And that seems to be what this evidence is getting at. So when walking through this hypo, the first question that you would ask, I think, to parallel what Lori said is, why is the defendant trying to get this in? Undoubtedly because there's some sort of self-defense that's at issue, and they want to show that Marcus basically started it, and that any assault that happened is going to be in self-defense. And so that's sort of the framing there for that. And under the character rules, especially under 404A to B, the general rule is that the defendant can get in character of the pertinent trait of the victim. Now, when they do, they sort of open the door to the other side. The prosecution can introduce the victim's counter trait, in this case, the victim's peacefulness, and the prosecution can get into the defendant's character trait for violence in response. So it's sort of a dual whammy if the defendant decides to open that door, but they're still permitted to do that under the rules. But this hypo has a few different wrinkles in it. The first is that at this point, there's been an allegation that's made of excessive force. We don't have, the hypo doesn't display or doesn't describe how we know this. Is it something that someone has reported to someone and it's in some government document somewhere? Or is it the complaint itself? Or is it actually the victim of this prior use of excessive force who's willing to come forward and talk about what happened? If it's either of the first two, there's a second layer hearsay problem that may be involved. If it's someone's report about what happened in an official report, the official report may be, fall into the official report exception. It may not. We'll get to that a little bit later on a different hypo. But there's a hearsay problem of just the report itself, or the victim's description that goes in the report is a second layer of hearsay. And same thing if it's just a complaint. That complaint is not going to fall under the official records exception. But let's just assume for purposes of argument that what we have is the victim of the prior use. And so therefore we don't have any hearsay problems because the person can take the stand and testify firsthand to what actually happened. That sort of raises the second issue about character evidence, which, as we all know, is the character evidence is limited into how it's proven. And there's three different ways to prove it. There's the reputation of the person in the community for the pertinent character trait. There's opinion testimony from people who know the person whose character is at issue about whether that trait is, and then specific instances about this is how they exhibited their trait on this date, and this date. And the general rule in Rule 405A, as we know, is that you cannot get into specific instances when it comes to the victim's character. You can do it for reputation and community. You can do it with opinion testimony, but you can't for specific instances. California has a different rule. It allows in specific instances in this particular type of narrow circumstance, but the federal rules don't. And this is an instance where in the book, California is one of the jurisdictions that we talk about. And generally what you'll see with the book is the book will have footnotes throughout it that will distinguish the law in the five sort of major jurisdictions that we look at where they differ. So there's a footnote in this part of the book that describes why the California rule is different. So the answer to this hypo is that even if we get rid of all the hearsay problems, this is a specific instance and therefore is not going to come in under the rule. And so that would be the answer to that hypo. There's also a question, maybe, is this habit evidence? If you get a particularly precocious student who says, well, what about 406? That there's at least one case that we've found that says that the use of excessive force is not routine enough. It involves too much of a filter through one's character to be considered habit. So it is not habit evidence either. Did you have anything that you wanted to add on this, Lori?
No, I think it's really helpful. Students don't actually appreciate in their lives, don't forget, character's used all the time. And so for them to understand why there are limits on character and how the defense has to open the door and what way you prove it is actually a little different from what their instincts might tell them.
The next hypo involves the prosecutor trying to admit medical records from the public hospital reflecting Officer Marcus's condition at the scene, which were made by a responding EMT. The defense objects hearsay in Crawford, so the issue becomes, how do you rule on this one? Again, there's a little bit of ambiguity built into the question, which you can sort of tease out or not. And that is what is reported in these public records or these medical records just the EMT's observations, or do they also include Officer Marcus's statements about this is what I feel, that the EMT is then just writing down into the report and then sort of adding his or her own notations about the diagnosis and prognosis of what's happened. If it's Marcus's statements as well, then you've got an additional layer of hearsay because you've got whatever was said that goes into the report. I think that additional layer is probably going to come in under the hearsay exception for statements of medical diagnosis or treatment. That, of course, raises the question about whether the EMT's statements and observations in the hospital records also qualify under this exception. Usually the rule is that what a doctor tells a patient is generally not something that is a statement made for medical diagnosis unless it's something that's going to be passed on to another doctor for further treatment. And in this case, it very well may likely be just that case. If the EMT is taking notes, those notes get passed to the doctor at the hospital, and the doctor at the hospital acts on those notes to treat Officer Marcus. So it's important to look at this exception as a possible basis for both layers of this hearsay. And the exception, again, this is a slide that's in the PowerPoint deck, lays out the requirements for this exception, that it's made for medical diagnosis or treatment, that it describes medical history, past or present symptoms or sensations, the inception of those, and the general cause, and that it's reasonably pertinent to diagnosis or treatment. And again, this lays out the elements in a sort of textual way. We've also got a graphic that lays it out as well, people who sort of look at things in that spatial way too. But that raises a different question, which is even if it qualifies as a statement of medical diagnosis, these are statements that are contained in public hospital records. And so it may qualify as an official record as well under the hearsay exception. And the public records or official records exception requires that it be a statement of a record, a statement or record of a public office, and it has to fall into 3 different categories. And again, unless it appears to be untrustworthy. And so again, graphically, we've represented this so that it qualifies and fits for records or statements that sets out the office's activities, which doesn't really apply here. That it deals with factual findings from a legally authorized investigation, also doesn't apply here. The most applicable one is the one in the middle, which is that it's a matter observed by a person with the duty to report. That is generally going to be admissible under this official records exception, unless it's a matter observed by law enforcement and it's sought to be admitted in a criminal case, which again, we have a criminal case and it's the prosecution that's trying to introduce it. That sort of raises the question, is this a matter observed by law enforcement? Is the EMT a member of law enforcement? And again, there's sort of the general escape hatch that if the record is otherwise shown to be untrustworthy, then it does not come in. So that raises these questions for the students to consider, which is, does the EMT have a duty to report? Are they part of law enforcement? And because the EMT statements might qualify as under the medical diagnosis exception as well as the public records, does either one of them trump the other if it doesn't satisfy both? Does the EMT have a duty to report? I think the answer is probably yes. In the hospital records, they have a duty to faithfully report what it is they observe. They are public employees if they're working for the public hospital. Are they part of law enforcement? We looked at cases all across the country. We didn't find anything exactly on point. We did find one case that dealt with whether or not an EMT that is working for the prison and is helping people in the prison is not considered to be law enforcement. Probably if they're just responding at the scene and they're not doing a forensic exam, they're probably not going to be law enforcement. But again, there's a little bit of ambiguity that's a good ground to discuss what are the policies behind the public records exception and why one way or the other it might be good to apply that exception here or not. And then the question also, the hypo also teases out a little bit of tension that exists in the case law amongst the federal circuits. If something qualifies as a business record but doesn't meet the official records exception, can you admit it under one and not the other? Some courts say yes, some courts say no. We haven't seen any that have applied it in this situation where maybe it doesn't qualify as a public record, but it does qualify as a medical diagnosis. But again, it's good. This is a useful tool to sort of tease out that potential ambiguity in the law. That raises the last issue, which is the Crawford objection. As we know, Crawford changed the law in 2004. Prior to that, under Roberts, the Confrontation Clause was really about reliability. So as long as there was an assurance that out-of-court statements were reliable, the Constitution didn't really worry about whether there was any cross-examination. And so what Roberts did is it applied the Confrontation Clause to all out-of-court statements admitted for their truth, but had a fairly porous rule that even if they were out-of-court statements admitted for their truth, they could still come in if the witness was unavailable and they fell into a firmly rooted hearsay exception, or otherwise there were guarantees of trustworthiness. Crawford changed that by saying the premise of the Confrontation Clause isn't reliability, it is what it says, which is confrontation. And it limited the scope of the Confrontation Clause to testimonial statements, as we all know, but then set up a very absolute back-end rule. If it's testimonial, you either have to be able to cross them now, or you have to have had a prior opportunity to cross them and didn't take it, or did take it, but there has to have been some other prior opportunity. Testimonial took a while for the courts to define what that was, but when they finally did, the general two criteria, whether the primary purpose was to gather evidence for prosecution or investigation, or whether or not they're looking at sort of the formality of the statement. I think it's fairly clear that a person's statement to the EMT or the EMT statements to the records are not really made to preserve evidence. They're made to provide medical care. So I think it's fairly certain that it is not testimonial. But again, there's no U.S. Supreme Court case on point. So that, again, is a basis for discussing sort of the contours and the evolving definition of what is testimonial. I think that covers all of three, unless Lori has anything further, we can go on to four.
Well, I actually want to make a couple comments. First of all, I think that students might be asked, what would you want to ask that EMT? What worries you about that EMT? Was he really just there to provide care? Does he look around and see a bunch of people that he works with, law enforcement, and therefore thinks that maybe there's some other things he should put in the record? So I think you're right, Brian, that generally those wouldn't be seen as necessarily testimonial in that way. But, I think people can think about it. The other thing is I want to raise the question of how long we're going to have Crawford for and in what form. Because Scalia, of course, was the big champion of Crawford. It then waned. Some of the people who are the least favorites of Crawford are the ones who are still on the bench. We know that this court is willing to re-examine decisions. And even though it was Scalia who was conservative, there wasn't a unanimous feeling that Crawford should be the way to approach it. For now, we're teaching our students Crawford, but we're beginning to see a slide back to that idea of reliability. Would you disagree?
No, I mean, I think there was a significant pushback. I was a bit surprised by the majority opinion in Hemphill, which, I mean, dealt with whether or not there was the equitable exception to Crawford. But even I think Sotomayor, I don't recall whether she wrote it or joined it, but it was some pretty strong pro-Crawford language about we don't like having equitable exceptions to constitutional doctrines. It embraced Crawford more than I thought it would. But we haven't really had a solid Crawford decision really since Ohio versus Clark that's really dealt with it head on. So it's been, that was 2015. So we're coming up on a decade since we've really had a court whose personnel has changed significantly really confront that issue head on. I think Hemphill left it open a little bit by saying we're not going to get into whether or not the rule against completeness trumps Crawford. So that may be another avenue they could revisit. I know California has its rule about it saying the rule of completeness does trump, but I'm not sure whether there's a split out there in the federal courts about that. But I do think that that's a legitimate question about, there's certainly a huge amount of disarray on Crawford and there's a lot of pushback, but there seems to be pushback going a variety of different directions. So it's hard for me to articulate any particular prediction about what's going to happen with that, other than it's uncertain.
I agree. And by the way, I am seeing people who are joining us on the webinar, and I want to say thank you to all of you. Chris Goodman, we haven't seen each other forever, so I hope after this webinar, we'll set some time together. The defense calls in issue number 4, Jeremy Joyner, a fellow kiddo, to testify that Officer Marcus attacked the defendant. The AUSA prosecutor seeks to admit Joyner's 2012 conviction for armed robbery. So here we're going to try to impeach. And the area of impeachment is something that I tend to teach in layers because there are different types of impeachment. We're going to get to the idea of convictions. But generally, if you think of convictions, you're going to want to cross-examine somebody to say, hey, if you're a member of the same group, or, you know, where are your loyalties, bias or motive, perception, recall, it's very chaotic of what's going on here. What's your character for truthfulness? What do people say about you? And there are limits on that, but, you know, it's interesting. And then demeanor, which is an unusual way to think about evidence, right? And I've written in the area, some of you know, the theater of the courtroom. Technically, what is happening all over the courtroom is not considered evidence. The one place that people do consider it, it tends to be from the witness who's up on the stand and whether they're being direct in their answering. But there's more specific impeachment, and that's the prior inconsistent statement. Did, in fact, Jeremy Joyner say something different before? Did he say it was always the officer who did the attack or someone else? That's very useful, right, to ask the witness. And then is there conflicting witnesses? Other people who were there who say, no, I saw what happened, and it's not this guy. So all of those need to be used in a case to explain how are you going to challenge the credibility. That's what impeachment is. And, you know, with recent political impeachment, you have to emphasize to students, we're challenging the credibility of the testimony. And here's all the ways we do it. In addition, and the next slide will help us raise this, the idea of piecing together 609. Now, we all know, if we teach evidence, that 609 was a huge compromise, that other states have a much cleaner or, you know, straightforward approach. If it's a felony conviction, certainly for one of moral turpitude, it's going to be used. And you don't have to look at all the balancings, although you often have to look at the age of it. But the federal rules were ones where the conversation began, well, so what if somebody has another conviction? Maybe if it's for truthfulness, we should allow it. But, you know, other things like for armed robbery, you know, you can have a really honest armed robber. And nonetheless, people went back to the common law times and say, well, that's the type of person who we can't trust to tell the truth. And that's how we ended up with Rule 609, which you all know has so many layers to it. And our goal is to try to help people, professors and students, tease out how you would go. So in this one, we've got a conviction. I think it's within the 10 years. I'm not sure, but it looks like it is. It's adult. If it's not adult and it's juvenile, there are going to be more limits on it. And then essentially step 1, what was the conviction for? Because if it's the conviction for things that go to truth-telling, like perjury or lying, which is evident from the pleadings, not that we have to go back and read the whole transcript, we're going to let that in. If it's for some other type of felony, it's going to depend on who the witness is. Is it the defendant or someone else? So let's go to the next slide, Brian. And Brian is brilliant because he can take all these ideas and put it in a chart that students actually can follow, and is a really helpful way to think about how we're going to be using 609. So what is the nature of the crime? Is it a dishonest act? As I said, I don't think robbery qualifies as a dishonest act. And let's not forget, if it is a dishonest act, it doesn't even have to be a felony. It could be a misdemeanor. Is it any other crime that's designated a felony that does not require dishonesty? Yeah, like bank robbery. So how do we go about looking at it? The rules came out, as the next slide says, if it's to impeach a witness who's not the criminal defendant, we're going to let it in. We're not so worried about that witness Maybe their feelings are hurt a little bit. Maybe they're embarrassed. But we really need to know whether they're telling the truth. So it's going to be admissible unless the party opposing impeachment shows that, in fact, that probative value to say that, that's not someone to be believed is substantially outweighed by some prejudicial effect. And you might think there, what kind of prejudicial effect? Well, if the prior conviction was some type of assault and we've got an assault case, maybe that's what we have in mind. The balance is different when it comes to the criminal defendant, because we don't want to put too much limit on criminal defendants to testify in their own case. They have to own their convictions. But in that way, it's inadmissible unless the prosecutor is now showing why it is probative and why the jurors won't misuse it. When it comes to the age of the conviction, if it's more than 10 years, if it's within 10 years, it's not inadmissible. But after 10 years, it's kind of stale, it's kind of old, people change, and therefore we're going to leave it out unless the party who wants to use it can show, no, Judge, they're giving a false impression that this guy is some kind of angel. We really need this for the jurors to hear it. If it's a juvenile adjudication, and I think judges are more committed to this than ever as they learn about youth justice, we're not going to use it unless it's really necessary. And maybe Brian has some ideas of the cases where it's really necessary. And so I think in this way, the students and even lawyers, because lawyers are often confused on this, can begin to understand sort of how you can go ahead and navigate your way through 609.
Yes. One other thing to add is the book does not just present the students with this complex chart that's up right now. What we actually do is in describing the sort of the three main ingredients into that, we build this chart one piece at a time. And I think there are 3 or 4 different charts where we'll discuss a couple of factors and then weave them into the chart. So the students see how this complex weave and tapestry that the drafters created with 609 came to be. And so this is a helpful, obviously, explanation of or summation of the law at the end, but we walk them through one step at a time in building this so they can understand how it all fits together. For issue number 5, here Joyner refuses to take the official oath. Instead, he wants to swear on, quote, the Imperial Wizard's immortal soul. The AUSA objects, lack of competency. How do you rule? We have a chapter that discusses sort of what the requirements are for witnesses to be competent and the 4 main pillars of competency that exist under the rules today, some of which are in the rules themselves, some of which are part of the common law that the federal courts apply. And those are the sincerity of the witness. Are they being honest? And how can we be assured that they're honest? How do we assure ourselves that they perceived whatever it is they're going to testify about, that they're able to recall whatever it is they're going to testify about, and that their ability to convey that information and narrate is sufficient that they should be able to take the stand. This is obviously aimed at sincerity, and the sincerity requirement is implemented through Rule 601, the oath requirement, and really it's an oath or affirmation requirement. And the book sets forth several different examples of cases where to drive home the point that there is no set of magic words that courts will require for an oath. It's just, is it sufficient that the witness understands the gravity and significance of telling the truth? And so anything from, in some cultures, banging on a drum, it doesn't have to be putting your hand on the Bible. It can be putting your hand on another religious text or just affirming. What courts are looking for is whether there's any loophole. We don't know enough right now to know whether or not if you belong to something called, the Oath Keepers or anything else, like whose oath you're keeping, or is it designed to sort of keep all oaths, including the oath to tell the truth, or is it any oath that sort of helps the organization and subsidiary oaths aren't all that important? We don't have the facts on that to be able to decide that. So that would be something that you would want to tease out with the students, determine what sort of gravity needs to be conveyed, and is this particular offer in this case to swear on the head person's immortal soul sufficient to convey the need to tell the truth. Anything you want to add on that, Lori?
I do. I want to jump in real quickly. Part of what we've tried to present in a teacher's manual, and as well as the book, is the idea of cultural sensitivity and biases. The idea that you have a code of evidence and therefore it doesn't have any bias, or there won't be bias in how it applies. Certainly the area that Brian just described can lead to that kind of conversation, but we also try to do so in the area of impeachment. Who's likely to be impeached with what and why, given the history of criminal prosecution in this country? Depending on your students and how you like to approach things, we will give you some opportunities, ideas of how these issues would raise those discussions. With that said, let me go to issue number 6 real fast, because I love it. It's great. It's got lots of fun issues in here. Here, the prosecutor seeks to introduce a video of the altercation as well as expert testimony, ding, 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 that the defendant is the person depicted in the video as the attacker. We know that there are thousands of hours of video that were made from different angles. The expert testifies first about how the video system operates. We need that. We need authentication. We need to make sure that what we're getting is reliable. 2, how the expert's forensic enhancement of the video shows a Yosemite Sam tattoo on the back of the attacker's neck that happened to match one on the defendant's. So now we need to know about the expert. What is the expert doing? Is the expert have the background, the credibility to do it, and does the expert use methods that we consider to be trustworthy in doing so? Is this an area where people are recognized as experts at all? And 3, how the attacker's gait and movements match those of the defendant. Now, at first, that might sound like expert testimony, but couldn't a layperson also do that? Say, I've seen somebody walk before, and that's the same walk. And so we often do lay testimony and expert testimony together, but somehow lay testimony gets lost. And I like to emphasize for the students that if it's lay testimony, great. If it's expert testimony, you're going to have to meet the requirements of 702. Before we do that, let's go to the next slide quickly. And we can talk about authentication. So with documents we're very used to, have you seen this document before? Are you familiar with it? We're living in a world where authentication is more complicated. But in some ways it's not. If it's somebody who's familiar with it, they can authenticate it. You can bring in experts to do it. You do have to dive into the idea of whether this process produces accurate results, and that was the process used in this case. So it's not as simple as it was, but in fact, I think in some ways students feel more comfortable in saying, calling a person, how was this video made? What's the process? Was the process used here? Next slide. Then we get into expert testimony. At 702, of course, I think that they have a clarifying amendment in it now, but this is an area where even the judges had to be taught. And the students often think of expert by how many degrees somebody has after their name. You all know that it's not. You can be an expert in identification of tattoos or the operation of an elevator. But you need to know, is this an area that the expert would know more than the jurors, right? And is it one that would be helpful to the jurors? Because what is not helpful to the jurors, and we talk about in the book, right, Brian, are experts on who's telling the truth. You can get around that a little bit with the eyewitness testimony. Experts on the law. We do have a judge who's paid to do that. So it's sometimes helpful to educate the students on when it invades the province of the jury. Next slide. Then we get into the difference between lay opinion and expert opinion. And again, as Brian has suggested, this is something we build in the book. We don't just give them a chart and say, figure this out. But again, the subject matter of whether it's something that's specialized knowledge or not, whether this person has an expertise, whether it's going to help the trier of fact, and really critically, what was the methodology? And we have cases in the case book that will point out how the courts are concerned about these various areas. So I think that identifying a tattoo very well could be, but you better know what measures the person uses. And it's always helpful to know whether they've done it before, but recognizing that in the federal system, we don't have the Fry rule, that it has to be generally accepted as it is in many states. There's one other aspect of this, Brian, if you go to the next slide, that I want to mention quickly is, so do you allow somebody to describe what's on the video? Is that going to violate, for example, the best evidence rule? Well, if you have the video, you should show the video. Obviously, that's what the best evidence rule expects, but it doesn't have to be the original of any picture. It can be a copy if it's reliable, and there are exceptions to it. But it's not impermissible, just under the best evidence rule, that if you're showing a video, to have somebody identify things in the video and what their importance might be. And sometimes I think there's confusion on that. All right. I hope I left you enough time to do the final issue
Yes,
here.
the number 7, the next one, and this is judicial notice question. Here, the prosecutor wants the court to take judicial notice of the fact that January 6th of 2021 was the date set for Congress to certify votes from the Electoral College. The defense objects improper expert testimony, best evidence rule. How do you rule? The book, again, there are topics that oftentimes don't occupy sort of the main part of the semester for those of us who teach evidence. But the book makes sure to cover the parts like judicial notice and privileges and the whole common law of privileges, so that if you choose to cover these areas that aren't sort of as central as hearsay and relevance and expert testimony, the book comprehensively covers them. As we know, Rule 201 of the federal rules breaks the universe of things that might be potentially subject to judicial notice into 2 pieces, into adjudicative facts and then into legislative facts. There are other jurisdictions, California, for instance, is one of them, that doesn't break it down. All of these things are subject to the judicial notice rules in California, but the federal rules only govern adjudicative facts. That is, those facts that are sort of case specific rather than things about what's in the law or general notions about how things work and how people work and the definitions of words. All those sort of fall outside of the ambit of adjudicative facts and the regulation by the rules. What's interesting about this is that the date that's set in the act is kind of illegal. On some level, it is a legal question. And what does the act prescribe as the date on which this happens? And the Electoral College Act actually says, it's January 6th of the year. So in that respect, it is a legislative fact, not an adjudicative fact, even though it's a fact that sort of matters, I think, to this case. But I think it is somewhat on the line in that regard. And again, one of the slides that you'll see in the PowerPoint deck deals with the requirements for those things that are adjudicative facts. That is, that they're not subject to dispute, and either they're generally known or they can be verified readily by sources whose accuracy can't be questioned. So there's all the other procedural requirements and the extent to which they are binding or not binding in criminal cases that also attach to judicial notice that the book covers as well. I know we have one further question, Lori. Do you want to cover it, or do we want to have time for questions?
I can do this really quickly as people are formulating their questions. It's really just a question of chain of custody. Again, this is where television has corrupted our youth, because you often hear the objection, chain of custody. And we all know that, in fact, in this hypo where, the witness says it looks nearly identical to the speaker's gavel, that was taken, objection foundation. Next slide. For foundation, it can be authenticated in so many ways. And proof chain of custody is not an absolute requirement. As we often hear, it goes to the weight. We're assuming that if they seize some type of gavel, and even as it hasn't been hermetically sealed in an evidence locker, somebody can say, yeah, it looks just like the one we saw. And if there are real questions, they can be asked on cross-examination about it. So we like to point that out. Next slide. We give you a case you might be familiar with that helps explain this, and sort of the drug area where it was real questions about when there's gaps in it. Next slide. And that in our slides, where we think it's important, we'll give you more language or less language, but ultimately it'll be up to you. These are slides you can change, you can modify, you can use for whatever purposes. So with that said, we are true to our word, and we have a few minutes for questions. Are there any questions? And let me emphasize again how grateful I am to Brian and to you for joining us on this.
Yes, thank you so much for this wonderful presentation, Lauren and Brian. So we do have a few questions. So I'll start with this one. How do you effectively communicate to students how much discretion judges have in making their decisions without making it seem like their 403 decisions are not arbitrary?
I think we should ask the judge that one. You know, as you pointed out, a lot of these decisions can go either way. So how do you explain to students that these really are rules in play as opposed to just judges doing what they
I mean,
want?
I think the way that I've done it, and I think I tried to briefly touch on this earlier, is that is to emphasize that there is a lot of discretion, that most evidentiary rulings are reviewed for an abuse of discretion, but that 403 balancing is even broader than sort of the general rule. What I've done is I walk the students through various hypos, and will either I use survey software so that they can see how everybody votes, and some of the times will be these questions that I use are based on real cases, and I'll say, well, the answer here is X. But in others, I'll say, you know, the answer here, I mean, unless it's something where the court has overturn something as an abuse of discretion, I'll try to emphasize, you know, this is where, you know, I think reasonable minds can disagree. There are some cases where the court affirms a ruling one way, and I say, you know, if I were the judge, I would have gone the other way, and I don't think I would have been reversed for that. And so I think trying to drive home that there is this band of reasonableness, and that not all reasonable minds agree on the same result, is sort of how I try to get at aiming at the breadth of 403. Do you do it differently, Lori?
No, I do that. I actually let the students sort of play judge and explain why they're doing the balancing. And in the book, as you know, Brian, we put in some interesting in the teaching manual and the book, I think, some of the new areas regarding balancing. For example, rap lyrics. And how does that balancing come out? Students appreciate the issues that relate to their lives. And they begin to see that it's, you know, it just because judges come out the other way, it does not mean that they're not thinking about the standards that should be applied.
And speaking of rap lyrics, I mean, one of the things that I know is in the teacher's manual is the fact that this is an area that is being very closely regulated, or at least monitored by legislatures. California's legislature just passed a bill on this. I believe that the Congress has considered them. So we have done it. We've tried to be very thorough in scrubbing across the board, not only for amendments to the rules, but sort of cutting edge areas where the law is in movement. And where the law may change. And this sort of is a subset of perhaps 403 type issues, but it is one that is important and that is of great importance. And I think feeds into what Lori said about the fact of the cultural sensitivity or insensitivity of the rules and how they apply.
Anton, any other questions?
Yes, thank you. So another question. What is the most effective way to incorporate Crawford into explaining hearsay exceptions? Is it better to give the students a quick overview and then go through the exceptions, or wait until covering the hearsay exceptions?
Do you want to do it, or do you want me to take it?
You can take it, although I will just preview for folks. I've tried it both ways. But how about you?
I usually sort of hint at Crawford throughout the class leading up to it, and I treat it as sort of an overlay over the hearsay rules. I go through the hearsay rules and say these are sort of how they work, and this used to be the solution to to the confrontation clause, but no longer is, and then sort of move away from there.
I see a wonderful comment by Richard on the chat. Can I mention something with regard to that? First of all, Richard, thanks for joining us so much. You're talking about expert testimony in 403, and you listed Mona Lisa Vito. I love My Cousin Vinny. I don't know how anybody teaches evidence without using that movie, and it's not so old that students don't know it. You know, where the prosecutor's junk science expert was called to testify, he could watch surveillance video and recognize cars in the middle of the night by the shape of the headlights. You know, I know that's a light moment here, but folks, some of you know I also run an innocence project in the area of forensic evidence. It's so important to deal with all these evidence. And yeah, Richard teaches in the criminal defense program. So important. Forensic evidence raises issues, everything from relevance to experts, to authenticity, to Crawford, and it's something that's just becoming more so in our system. And by the way, students still love the story of Sir Walter Raleigh. So when you teach Crawford, they're great pictures, did great stories about his wife carrying around his severed head for many years after his trial. Just a note.
We're close to our time, I guess, but let's do one more question. Impeachment tends to be very confusing to students. Some states take a much simpler approach than Federal Rule of Evidence 609. Why is 609 so complicated in comparison to other state approaches?
I'll take that. As I mentioned, it's because the federal rules and the way they were made, which we don't often spend a lot of time on, it's almost like a legislative process, and that's messy. And so they had common law and different approaches to consider. And this was back many decades ago. Now, they could change things, but we tend not to because we get used to doing it this way. And I think that they thought that this was a balancing that would be more fair. But Brian, when you talk about the complexity, because you're in California, the California approach versus the federal approach, do you have a specific take on
Yeah,
that?
I mean, I emphasize sort of the fact that I spend a good part of 2 hours teaching 609, and it takes me about 15 minutes to teach how California does it, sort of vividly illustrates how much more complex the federal rule is than California is. Yeah, you just look at the age and the type of conviction, and is it going to keep the defendant off the stand too much? And that's basically the sort of 403 like balancing that you engage in. And it's much simpler, but also doesn't give as much direction as far as categorical rules. And it's sort of the trade-off of certainty, which is what 609 gives a lot more of, even though they're still balancing at each level, versus just flexibility and ease of application.
All right. Well,
Wonderful.
Well, let me sort of offer this in conclusion. My heartfelt thank you to you and to Allison and to Brian and to the people who are attending and the people who will watch this tape. I also want to offer up that in addition to all the things we described in this book, you have us. And you have us 24/7. So if you want to text me or email me, if you have questions, by the way, I know that there are a lot of good authors out there on evidence books. I've used many of them. I've been teaching at Sincerity. But the only other thing I can offer to you is call us, or call me at least. And I'd be happy if there's a specific issue that comes up in your class to try to get you pointed in the right direction, because we all want to help our students learn.
Absolutely.
Wonderful.
Thank you so much.
Thank you so much for your presentation today, and thank you all for attending. Today's webinar has now ended, and I hope you have a wonderful rest of your day. Thank you.
Thank you.
Thank you.
Bye, everyone.
Bye.
Yeah.